Okay, so I'm back. Deb Kuether for Deliberate Indifference, Wisconsin, and Wisconsin. So I am following up. There are two videos that are out right now that where I read through the Fermin versus Hitchcock Cross and Kuether complaint that was filed against us for defamation because of this YouTube channel. And so I encourage you, before you watch these videos, to watch that word by word reading of those complaints because that gives you the context. But now I want to go ahead and I want to read some of the other documents that are have been provided to us, and also not this particular document, but another one that is part of the record. But I'm going to do them in the chronological order that they were provided to us, and so you can see how this has evolved. So after the lawsuit was filed, these documents that I'm showing you now were provided to us by Mr. Fermin because he is representing himself. So these documents were provided, and I call them the menu of free speech. And so the reason I call them that is because what Mr. Fermin has offered in this particular document, or this offer, is a variety of options for us to consider what kind of level of defamation he can tolerate and how much we would pay for that. That's kind of how I see it. Like, he's making these defamation claims, but, you know, some of them can be remedied and not be taken down if he has provided a certain amount of money. So let's just go through his options. And he provides three options. They each come with a different amount. So option number one, which is right here, he's suggesting that Mr. Hitchcock Cross and Dr. Kuether agree to pay Mr. Calvin Fermin the sum of $200,000. So for that $200,000, we could purchase defamation, this amount of defamation, and he's described it as removing 5 videos, and he lists those videos here. And then he also suggests that we make a favorable video about him, so that would maybe counter the defamation that's been out there. And then he does make a statement that we agree not to use his photographic image on any video thumbnail that they post on Deliberate Indifference Wisconsin YouTube channel. And he goes on to say where he's had those before. We have to also agree that we do not ever speak of such things again with his name. And we have to dismiss civil action against Mr. Fermin. So that was option one. Okay. So that, like I said, that was $200,000. So now for option two. Okay, so this one is like kind of a sale or a reduced coupon. I don't know if we have to turn a coupon in or whatever, but like we can get a big savings if we go this route. So let's see what he suggests here. For this one, we only have to pay $150,000 to him. We still have to remove all 5 of those videos, but we also have to remove all of his deposition videos that were taken by Cream City or Vertex. I don't remember which company I paid to do those, but he lists them here. We do not have to make a favorable video in this one. So for our $500,000 savings, we do not have to make a favorable video of him. Now here he swaps out, or not swaps out, but since we don't have to make a favorable video, we also cannot use his image anymore, but we also cannot say his name too. So no more saying his name. All right. And so that's what that $50,000 savings gets us. And then he's got, he's added these claims and counterclaims because, but after we pay him $150,000. Now, option 3 is $100,000. So now we can save up to a whole $100,000 that we have to pay him, but we would still have to pay him $100,000. So in this one, he's still got all those videos listed, but he crosses out the favorable video. He still has the photographic images and name, but now there is this non-disparagement claim. And this, I think, is, must be the thing in the defamation that he's equating to $100,000 of damages from his original statements. We still haven't seen any evidence of any loss that he's suffered. He has not provided that to this point. Actually, he has admitted the contrary. But he does say defendant Hitchcock Cross and defendant Kuether jointly and severely agree to not at any time make, publish, or communicate, either verbally or in writing, in any public forum or social media site, including but not limited to YouTube, LinkedIn, X, formerly Twitter, Facebook, or Instagram, any defamatory or disparaging remarks, comments, or statements concerning plaintiff Fermin. Nothing in this section shall prohibit the defendants from participating in any litigation matter, to include giving testimony or providing responses in discovery. All right, so, and then he's got all the other things that he had before where we dismiss anything that we could ever do that would include him. So that was what I call the menu of free speech. Okay, so that was a menu of free speech. That came along, and we got that just shortly thereafter, finding out that we were served. And so I want to now go through the default judgment that Mr. Fermin filed against us. And let's just read this like I've been doing before. Please take notice that plaintiff Kelvin Fermin herein moves the court pursuant to Wisconsin statute 806.02 1 and 2 to strike defendant Kuether's answer, affirmative defenses, and counterclaims, and to enter default judgment against both defendant Kuether and defendant Hitchcock Cross. This motion will be heard on Monday, March 4th, 2024, 1:30 at the Milwaukee County Courthouse, room 412, before the Honorable Glenn Yamahiro, branch 34, or as soon as the matter may be heard. And we did have that hearing. He required the court to go through that, and obviously it was not, a default judgment was not issued because it was not in the interest of justice. So for this motion, I'm going to keep reading. Plaintiff Fermin hereby states that defendant Kuether filed and served an unsigned answer, affirmative defenses, and counterclaims, and therefore said answer, affirmative defenses, and counterclaims should be stricken from the record pursuant to 802.05, parent 1. Additionally, Plaintiff Fermin has filed an affidavit of defendant Kuether's default for failure to join issue. Defendant Kuether's answer, affirmative defenses, and counterclaims was filed and served late, and defendant Kuether has not moved this court for an enlargement of time to serve an answer. Therefore, defendant Kuether's answer, affirmative defenses, and counterclaims should be stricken from the record, and default judgment should be entered against defendant Kuether pursuant to Wisconsin Statute 806.02, parent 1. Likewise, plaintiff Fermin has filed an affidavit of defendant Hitchcock Cross's default for failure to join issue. Because defendant Hitchcock Cross has not filed an answer or moved this court for an enlargement of time to serve an answer, defendant Hitchcock Cross's time to join issue has expired, and therefore default judgment should be entered against defendant Hitchcock Cross pursuant to 806.02, parent 1. Now here's the real whopper here, which is pursuant to Wisconsin Statute 806.02, parent 2, plaintiff Fermin hereby states that his demand for judgment is for a sum total of $750,000, or such amount that the court deems just. This demand includes compensatory damages, general and special damages of $250,000, and punitive damages of $500,000, or such amount that the court deems just. And that, my friends, is what equal rights looks like in Wisconsin. And that's one of the filings of many in the case docket for Fermin versus Hitchcock Cross and Kuether.